Viewers, welcome to the Personal Injury Law Show. This is a show that talks about everything current in the law of personal injuries and of interest to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer of 30 years experience. With me today I've got Don Maffia. He's the partner in transport accidents at a law firm. Good evening, Don.
Good evening, Tony. Good evening, viewers.
And also Nunzio Tartaglia, a partner in insurance law at a law firm. Good evening, Nunz.
Good evening, Tony. Viewers, welcome.
Tonight, viewers, will be dealing with a couple of very interesting cases that have gone to court. So stay tuned to see what the results were.
Before we kick off though, Tony, what's in the news?
Nunz, there's been some ripper and very, very interesting cases. The first one's about a pub where one of the bouncers lost his sight.
No, that's right, Tony.
Tell us about that, Tom.
You know, there's a security guard at the Phillip Island Hotel, one of the pubs in Phillip Island, and the security guard was evicting a drunk patron, and whilst doing so, another patron pulled out her hair extensions from a handbag and swung it at him and took his eye out.
Now, Nunz,
Yeah.
why would there be negligence if all you're doing is evicting a patron?
Oh, look, Tony, you need the background of the case to really understand where the negligence is. Basically, it was obviously a crowded pub. There was a lot of rowdy, drunk people, and what has been disclosed in the paper is that they were free pouring alcohol. There was sort of no rules, regulations. Everybody's out of control, and effectively security couldn't handle the mess that was going on.
Actually pouring alcohol into people's mouths.
They were free pouring, just like that, Tony.
That's bizarre, isn't it?
And Nunzio, there was also the security guard company told the owners of the hotel they should stop serving alcohol, and they didn't listen to that.
So Excel Security, who's a security company engaged in this for Phillip Island Hotel, reported to the hotel that, look, you've got to stop because it's just, it's going to get out of control. They didn't listen, didn't heed advice, and this is what's happened.
And surely it's got to be in breach of your liquor licensing.
Look, if we're looking just at the liability side of things, Tony, I think that the hotel's in a bit of trouble.
I think so. We'll come back to this in due course. All right, what's this about people playing in parks, cricket matches in this case, and the fellas sustained a very nasty injury?
So an SES worker, they had a social game, but it was organised by the employer at a local park and playing cricket, and then he's fell over a park bench and sustained pretty serious injuries. And effectively what's happened is the VWA, because he's lodged a work cover claim, is suing the council, Don.
Well, there's two actions. There's the worker suing the
Employer.
for failing to do a risk assessment, and then you have the employer or VWA, the insurer, the work cover authority, suing the council for not ensuring or failing to ensure the safety of a park. In this case, it was foreseeable that they'll play sport on it. And
Look, this is one of those classic cases where the employer's got to beware. I mean, let's be realistic. You've got them playing in the car park, football, rugby. I mean, they're not the appropriate places to be playing these sports.
Yeah, look, you make a valid point. I think the liability is more on the employer side because they've organised it. But attaching to the council, I think that's a bit of a stretch.
Yeah, I think so.
Well, I guess where does it stop? Because they're saying the council should not have let these type of games take place in a park. But
I mean, how often did it happen a lot? Perhaps that's what the argument is, Don.
Well, are they saying that you've got to make sure that every single park in the state has to be safe to play sports? I think public policy has to
they've played on this park quite a few times.
Look, and as we know, the councils are very much, they are a protected beast by both common law and statute, and I think this should sort of go beyond what's reasonable. That's my opinion.
Yeah.
Nuance, this is a very tragic case. Yeah. A girl's thrown from the ride at the Royal Adelaide show, and she dies.
This is a horrific case, Tony, and only happened obviously recently. And she was on a show with another young girl, and unfortunately she was thrown from the ride. Was taken to hospital and passed away shortly thereafter. And there's now an investigation by WorkSafe South Australia, because it happened in South Australia, into the ride and whether there's any appropriate breaches. But just look horrific, it's sad, and there's not much more to say about that.
And Don, in this case here, the claim would be by the family members for shock.
Well, it would be, and in terms of how it will happen, I think they haven't still worked that out. There's some investigations still ongoing. The initial investigation said there was no obvious compliance breaches on the actual. It was called an Air Max 360, so it looks like a big octopus just going round and round.
Yeah, but how do you get ejected? Obviously, she wasn't properly restrained.
There is also, subsequent to this article here, I think there was some suggestion that maybe she wasn't restrained properly. So look, it's very tragic. But Nunzio, you've acted for people in these similar situations.
Yeah, look, I've actually got a current proceeding on foot from a girl who was thrown from a char ride, and look, in this case, there's been breaches in that regard. But look, they're dangerous. They're dangerous, these rides, and if you're not doing the proper checks and balances, injuries or deaths can occur. And We don't want to see this again.
Well, Don, the important thing is that the actual operator was fined $36,000 by the Industrial Relations Court because they found that they did not have sufficient technical expertise to control a machine.
That's right. And that was back in a couple of years, 2006, Tony. But yeah, look, that's right. So, look, the investigation's still ongoing. Well, it's not quite sure if it's...
Look, Tony makes the point because the history of how they've managed the ride and what they've done in the past is going to be pretty important, Don.
Of course.
Yeah.
All right. Don, you've got young children.
Yes.
Play equipment has children falling into trouble.
Yeah.
There's a lot of ways of getting injured in these playgrounds and in these shopping centres and that where they've got the play equipment, correct?
Look, so my worst nightmare is the playground because you just see how many ways they can fall. And being in personal injury, you see this happen time and time again. There has been some research out there which suggests that there's more incidences or hospital visits from falls rather than car accidents for young children. And I can see it happen. I mean, you see these things 10 metres or whatever, a couple metres high off the ground, they fall over, broken arms, broken legs. It's a scary thing for a parent. But yeah, I think it's just we've got to ensure that playgrounds are safe and they according to the standards.
Nunz, what role does the parent play in all of this? I mean, you can't just go to a pub or a club or a restaurant and just dump them in the playground. No. There's got to be supervision.
The parents have got to do, sort of do their job and supervise, but at the same time, I think what the issues with these playground equipments is that they're going to change the height of the maximum height from 2.5 to 3 metres, which is the same as the European standards. And I think that's where the issue of contention is because they're saying it should be reduced because that's where all the injuries are occurring. It should be maybe a height of 1.5 metres, which, look, I think is suitable. The young kids...
I think supervision's the key to the whole deal.
I think it's both, Tony. Set up and supervision. So.
Oh, look, most definitely is. And look, I think even with the height restrictions as well, you've still got to keep an eye out for the kids. I mean, anything can happen. They can trip and break an arm.
Just quickly, I want to go to this MH17. Families are going to sue the Ukraine government. I would have thought the actual aviation authority that controls the airspace is in the gun too, because they said you can fly at 33,000 feet. But these missiles hit 50,000 feet.
I think you could be suing a raft of parties in this case, Tony, because I think, and I don't think we'll ever actually get the true answers, but I think you could sue 3 or 4, the government, the airlines, everybody in this case.
Well, in this case, they're suing Ukraine for failing to close off the flight path, which they couldn't guarantee the safety. So, look, there will be lots of litigation from this, Tony.
Anyway, look, I want to come back to this because it's very, very interesting, very tragic case. And I actually knew one of the 2 of the people that died in Australia. Okay, viewers, we're going to go to a sponsors break. After the break, we're going to be dealing with some very interesting cases. Viewers, welcome back to the show. We're going to give you 2 very interesting cases that were actually run in the courts in Victoria. The first one's a case of Stabilch and Harris. Don, give us the facts of this case.
So, Tony, we had to form Mrs. Stabilch in this case, and Mrs. Stabilch was involved in a transport accident out at the back of Shepparton or Numurkah. And what happened was on this particular day, Mrs. Stabilch was invited to attend a farm, a sort of a property up in Numurkah. So he went there in the afternoon and he was invited by his friend. He gets there, and when he gets there, there's who is now the defendant, Mr. Harris. He was there, it's his property. He had a 4-wheel drive. They all sat around with Mr. Bilge and his friend. They all had around a few drinks, and then they decided later on at night to go to the local town to have a few more drinks. So they go to the town of Numurkah. Then they go to Shepparton, and then on the way back from Shepparton, the car's involved in a rollover, the driver lost control, flips over, 2 people were ejected. So Mrs. Stabilge was ejected. Mr. Sortino, who was Mr. Bilge's friend, was also ejected and deceased. Harris remained in the vehicle. He got out of the vehicle, and the first thing he said was that Mrs. Stabilge was driving. Mrs. Stabilge was in PTA. He had very severe injuries, close head injuries. And the first thing he said when he woke up out of PTA was, I was a passenger. So the whole case was around who was driving this vehicle.
Nunz, what was the extent of Mr. Stabilch's injuries?
Well, look, they were, as Don said, it was a closed brain injury. He was in hospital for quite some time, Don.
Quite some time. And
extensive. I went and saw him in hospital.
Well, there you go. So look, they're sort of life-changing injuries, and look, I understand he's been on TAC payments ever since.
Oh, he's
and will do so indefinitely. So we're talking some sort of catastrophic injuries here.
Yeah, and the issue was not on negligence. Negligence was proven.
Well, it could have been negligence because it could have been an argument about knowledge about the alcohol.
Well, that's right, but the negligence proven, which is all we had to prove, was who was driving the vehicle.
I suppose the facts came out there was nothing else that could have caused the accident, so that's why negligence was an issue. That's what you're saying.
That's right.
There was another car involved.
No.
There wasn't.
There was an animal on the road.
So that's why negligence wasn't an issue.
That's right.
But the defendant could still have turned around and said, okay, negligence is an issue in terms of who was driving, but furthermore, we want to raise the argument about voluntary assumption of risk.
Well, the argument was, first of all, work out, the question that was put to the jury was, because this proceeded before a jury of 6, went over 4 weeks in the Supreme Court of Victoria before Her Honour Justice Williams, and the first question put to the jury was there negligence on the part of the defendant, so Mr Harris, which was a cause of Mrs Spilger's injuries, loss and damage. Then the next question asked after that, if he was found to be the negligent, which means he was the driver, the defendant, then was there any voluntary assumption of risks? And in alternative, was there any contributory negligence by reason of jumping in the car?
Look, the thing is, all these people in the car were pretty substantially intoxicated. What were the readings, Nuts?
Well, look, Tony, the readings were obviously Mr Harris was found to be the least intoxicated, but they were all over the limit, okay?
That's correct.
And so that's why I think the facts came into issue, because who are you going to believe in this case? If I was a jury member, you've got 3 people over 0.05, who is the driver?
Well,
and that's what I think the jury had to grapple with.
And we can safely say that all parties were blind.
Look, it was
Drunk.
blind, a lot of drinking. It was conceded when everyone gave evidence. It was that there was a lot of drinking involved.
And even the vehicle was full of cans and there was a smell of alcohol in there.
That's right. So there was a number of issues. So really, I mean, this case went on for 4 weeks. It's hard to sort of just summarise it all in.
All right, well, let
in
me
a
take you through a
segment.
couple of the main points.
Right.
The key witnesses in the case. The first 2 people that rocked up to the scene were Troy and Denise Clark.
Yep.
What was their contribution to these proceedings?
From what my understanding of the case, and Don can maybe expand upon this, look, I think they just obviously attended the scene, saw obviously a flipped vehicle, and then called the relevant authorities. But in terms of any evidence about who was driving or not, they couldn't lead any evidence. Is that right, Don?
That's right. But what they could say is that the first thing that pretty much Mr. Harris, the defendant, said in this case was that I wasn't driving, Mr. Bilge was driving, and I don't know him. Now, that was very relevant to the case because Mr. Harris and Mr. Bilge had met a few times before in the social occasions. So, Mr. Harris's, the defendant's denial of knowing the plaintiff
Was one of the things that helped.
one of the things that helped Mr. Bilge because his denial. Why would he deny?
So why is he denying, Don?
Well, what is it denying? Well, look, the motive behind it is because also the defendant in this case, Mr. Harris, had prior drink driving convictions which came out in evidence. The relevance of that is it goes to motive. The motive that were put to him was saying, well, you denied you were the driver because we would have noticed that there was 2 people ejected from a vehicle. He knew one was dead, which was his Mr. Sortino, who's his brother-in-law. And if he's caught, he's going to be doing a lot of time in jail.
All right, and there's also the moral issue of killing your brother-in-law, I guess.
And that's all right. So it goes to motive. So his denial not only to the first witnesses on the scene, but also to the police officers of knowing Mr. Bilge, I believe went a long way.
And Nunz, the other thing that was pretty important is this. The judge in the case ruled against us on the issue of putting to him the prior convictions because she said that we can't use that to determine that there's a pattern of drinking here. But having said that, when he was asked in cross-examination whether he's been in trouble with the police before, he's volunteered the information.
Well, it couldn't go to tenancy, and there's a lot of restrictions in the Evidence Act about tenancy evidence. But because of his denial, it was put to him, you have any drink? He actually said, I never drink and drive. And because he said it that way, then we couldn't get in as a credit issue.
Nunz, in addition to a lot of police officers giving evidence, there was a couple of forensic pathologists and also engineers giving evidence about blood spatter patterns and rollover patterns and structures.
Well, one thing was the seatbelt. The driver's seatbelt, according to the police who investigated the vehicle afterwards, appeared to be in use. The reason why is because there were scuff marks. Scuff marks is when there's accidents like this, when the seatbelt locks, you'll find that when it retracts back, there's all like little black marks on it, like scuff marks, it's stretched and all that. And they found it in the driver's seat.
So that suggests that because Mr. Harris had the least injuries out of everybody, he obviously had the seatbelt on, and it was obviously, you could infer that he was driving.
That's right. But at the same time, when they righted the vehicle, because the vehicle flipped 1.5 times, when they righted the vehicle, the passenger's seatbelt was also extended, but had no scuff marks. So the evidence led about that is to say, well, maybe it was in use, but most likely not, because if there's a person in that passenger seat, there would be scuff marks. It may have been damaged. But the driver's seat, the evidence by the police, and particularly our expert witnesses say, well, is the scuff marks was used, so therefore, Mr. Harris was the one who walked away from this incident with only a laceration on his arm, the defendant, so therefore he must have been restrained.
It goes into melting pot.
Exactly.
Viewers, we've got to go to a sponsors break. After the break, we'll give you the result of this case. Viewers, welcome back to the show. Don, in short, what was the issue about blood spatter patterns?
Well, there was blood spatter found, droplets found on the passenger side, because the vehicle ended up on the passenger side. And the evidence behind that was that it was low velocity blood, which means dripping blood. So therefore, it wasn't like a shotgun splatter everywhere. It was just dripping blood, which suggested that the blood came after the rollover event.
And how important was that to the result?
Very important, because it suggests that the person was still in the car where the blood came from.
Okay. Nunz, what happened? What was the result?
Well, Mr. Sabilch was successful. The jury found that he wasn't the driver, and Mr. Harris was. The damages were agreed to, and Don, what was the amount of damages?
The amount of damage is $497,000, which is the maximum amount allowable for pain and suffering.
But he stays on payments.
And he stays on payments, but and also it was agreed to 35 contributory negligence. During the trial, it appeared that wasn't likely that we put that to the jury. We decided to agree to it. It was 35% reduction for failure to have a seatbelt
and drinking.
Yep.
Okay. And viewers, the sad thing about this case is that this poor plaintiff was put through the test twice. He had to defend a criminal proceeding against him for culpable driving, which he beat, and then he had to run a 4-week trial to get his damages, which he succeeded in. So it's pretty tragic, very expensive, but fortunately for the plaintiff, he got his day in court and succeeded.
Yes, succeeded.
All right, Nunz, give me the facts of your famous decision of the Young and the Shire of Campaspe.
Look, Tony, it's an oldie, but it's a goodie, and I always like talking about it still. It's effectively Mr. DeYoung was at the Tulleen Waste Transfer Station back in 24 November 2002, and to put it simply, backed up his ute onto the, where the bin was. He had a range of hard rubbish he wanted to dump. Now, the bin in which he was depositing the rubbish was about 1.2 metres above the ramp. So he got his 17-inch TV, put it on top of the ledge where the bin is, pushed it, and unfortunately, the loose cord that was coming out, that was attached to the TV, when the TV was getting deposited, flicked up and hit him in the eye.
Yep.
Simple as that.
And there was signs saying that he was prohibited from leaving anything beside the bin. So he had no choice but to put it in the bin.
No choice to put it in the bin, and look, there was no supervision around, no one to assist him, and let's be honest, it's a country waste transfer station. Not much happens out there, so
except for dumping rubbish.
Don, what was really critical in this case was that there was a document entitled Guide to Best Practice at Transfer Stations.
Yes.
Now, tell us a bit about that document.
Well, there was a document which suggested how to manage or set up these waste transfer stations, and particularly when you're looking at people who you will go there and dump the waste in these type of bins. And the guys pretty much said that, like in this case, there was expert evidence to suggest that the ramp itself should have been, well, there's a couple of options. One of the options was the ramp should have been equal to or even to the...
It's amazing. You think just the waste transfer station, there wouldn't be a lot of documentation around it, but that the investigations that went into it, and then what we found was incredible how much documentation there was about it. And like this guide was like the Bible, Tony. It was very useful for the case.
But no, I mean, there's many. As you probably know, how many waste transfer stations did you attend in preparation for this case?
Well, we went to, I think, about 34 in totality and got photos of all the different setups, and not one was like this one.
So 34 waste stations in Victoria alone.
Oh, no, there's a lot more.
Yeah.
Right. Tell us some of the factors the court looked at in finding whether there was fault or not.
Well, just quickly telling you, it was obviously before a jury in the county court, and then later on we'll talk about the appeal. But ultimately, what it was found is that a few things could have been done. One, the ramp could have been at the same level as the bin, which obviously you can just put the rubbish in, but then you might have a rail at about 1 metre. Signage or supervision. They were probably the main three, Tony. And the guide obviously assisted, and also we had some expert evidence from Mr. Richard Lightfoot, who's an engineer. And
that helped.
Yeah. That was of big assistance.
Don, obviously the jury didn't particularly like the plaintiff outright because he lost the sight of his eye effectively. They only gave him $34,000.
Which seems a bit light,
So realistically, they probably thought, we don't want to look after him, but we don't want to not look after him.
Yeah, look, 34,000, is very trivial in the scheme of things, and it's sort of sad that it ultimately got appealed as well, and the costs would just outweigh the benefits.
All right. Well, what was critical in the Court of Appeal, Don and Nunz, is that the defendant argued that it wasn't reasonably foreseeable that you could throw in a TV and the cord would flick back and hit you in the eye. Yeah. And what did the court find, Don?
Well, the court didn't accept that because actually the defendant contradicted himself. The defendant raised a case that it was a freak accident. How can you foresee something like this happen? It's just a freak of nature. It just happened. But then at the same time said, but the plaintiff caused his own injuries because he threw the TV over. So contradictory. Yeah. And look, you read through the judgment, and when you were there, Justice Ashley, the three justices of the Court of Appeal just really shot that down, did not like that argument.
Well, I mean, the reality, Nunz, is this. You can't, on the one hand, argue that it's a freak accident and it's not foreseeable, and then say that if it was an accident, it was the plaintiff's fault.
Yeah, and look, they withdrew mid-trial their claim for contributory negligence, which, to be honest, I would have kept in. I think that was probably more of a pertinent point, but they wanted all or nothing, and it didn't make sense. You can't have it both ways. And look, Justice Ashley sort of gave it to him, to be honest, in the judgment. So,
but this is sort of a bit of an indictment on our legal system that a poor fellow like this, who's got a really nasty injury done, only gets $34,000 and a bit more, and you got legal fees of what sort of money we're talking?
Oh, we're talking hundreds of thousands, Tony.
It's insane.
And look, don't want to go into too much, but obviously, we tried to resolve it obviously before court, couldn't, and this poor Mr. DeYoung went through all this, 2-week trial, and then obviously had to wait for the appeal decision as well, and not seeing much at all.
You think it would have been cheaper for the defendant just to buy a sign?
Well,
compared to all the legal costs.
It would have been cheaper just to pay some money.
Well, the thing is, one of the things, and I see that the ramp compared to the bin, they only had to drop the bin by or increase the ramp by 20 centimetres to make it in accordance with the guidelines, the best guide, best practice.
That's
and all
still
those
not
things.
here nor there, is it?
Look, I think the defendant, the way I viewed it, just didn't like the idea of how this happened and believed that they just went to fault and we're running this all the way. And I don't think they actually looked at what's required to win this case. And that was proven because they led no expert evidence and was trying to allege it was just a freak accident.
Okay, both cases show to us how complicated the law is.
Yes.
So, if you're an injured viewer, or if you know someone that's been injured, what do you suggest, Nunz? What do you suggest?
You've got to speak to lawyers, because you can look at these two cases. You've got, Mr. Stabilch, who he was charged with culpable driving and then end up getting a result for him. Mr. DeYoung, who on the face of it, you feel like he's a bit of an innocuous accident, but it was proven that it wasn't. So, you've got to speak to a lawyer because we can find avenues, and that's our job.
And the main thing is you've got to start investigating from day dot. Don't let it go. Don't wait a couple of years. Do it straight away because the evidence is fresh.
Important point. Yep. Us lawyers generally want to get involved early.
That's right.
When you've got all the evidence in front of you.
That's correct. So
evidence doesn't get lost.
That's right. So it's day dot. Start investigating straight away. Because particularly like you see in both cases, and Mr. Young and Mr. Bild, in both cases, the facts are very difficult to prove.
Very complicated.
Many years down the track. So if you've got the evidence secured at the time, it makes little things easier.
Don and Nunz, thanks for coming on board. Viewers, thanks for watching. Stay tuned for future episodes. Remember to go to our Facebook, website and Twitter, and always remember to stay safe.